Hi there, my name is Jon Hummel and I'm with the National Foundation for Gun Rights. And this morning I wanted to talk to you about a recent ruling that came out of a 3-judge panel in the 11th Circuit. It's surrounding bans on 18 to 20-year-old firearm purchases. The case that we're going to be talking about today is called the NRA versus Bondi. So this ruling is the result of a challenge to a Florida law restricting 18 to 20-year-olds from purchasing firearms. Now, there's a national ban on 18 to 20-year-olds purchasing handguns, but this is just a general ban on firearms, no matter what the type is, for people between the ages of 18 to 20. And the reason we're deciding to highlight this case today is because it reveals a tactic that the left is going to keep on using after they've seen some success using it in this case. Now, before we get into all the nitty-gritty of this, I just wanted to say, please like, comment, subscribe, talk about why you hate gun control in the comments. Be sure to hit that notification bell. We just want to see you engaged and tell us what you like and what you think about these videos and what you'd like to see in the future. That'd be a great way for us to give you good information that you care about. So one of the major takeaways from the Bruin ruling that happened last summer is that the courts now have to consider the relevant historical traditions and laws that were in effect at the time of whatever amendment you're talking about was ratified and put into place. So the court in the Bruin decision stated, not all history is created equal. Constitutional rights are enshrined with the scope they were understood to have when the people adopted them. So Bruin identified 2 places that are important when considering any infringement on the Second Amendment. The first would be in the founding era, which is around 1791. That's when the Second Amendment was adopted. So that's the most important. And then the other one is around 1868, and that's the Reconstruction era. That's when the 14th Amendment was adopted. Now, the reason the 14th Amendment matters is because the 14th Amendment states, it talks about applying basically all of the Bill of Rights and all the amendments in the Constitution to the states. So it's something that moves the Second Amendment from being just a federal rule to being state rules as well, and something that has authority in that arena. Now, it may seem obvious that any law that deals with prohibiting individuals from owning firearms should really take most of its cues from that founding era, or the time around when the Second Amendment was ratified, since this is literally dealing with an individual's right to bear arms. If we focus on this era, it really leaves very little room for the court to decide or come to any other conclusion besides, this ban for 18 to 20-year-olds is not constitutional. It just doesn't align with the laws in place and the way that the historical tradition was when the Second Amendment was ratified. And this is where the left has decided to attack this from a different angle. So the court ruled in this case, in our view, though the Reconstruction era historical sources are, in our view though, the Reconstruction era historical sources are the most relevant to our inquiry on the scope of the right to keep and bear arms. That is so because those sources reflect the public understanding of the right to keep and bear arms at the very time the states made that right applicable to state governments by ratifying the 14th Amendment. Effectively, what the courts have done with this move is they have really tried to move the goalpost. They're making a new target that is much, much more achievable for them to be able to regulate away your Second Amendment constitutional rights. You see, in the nearly 80 years between the Second and the 14th Amendment, there had already been a few laws written where states had really started to crack down and constrict Second Amendment privileges. It's not nearly as much as this court would have you believe, but it was just enough for them to justify their ruling. This ruling, it was clearly driven by an emotional means-end scrutiny specifically barred by Bruin. This is something that Bruin said you can't do. And the reason I bring that up is because if you listen to the opening statements of their case, it's clear that they were just looking for a way to rule in how they saw this case and the way they wanted it to go. Here's their opening statements. In Ohio, a 19-year-old son shoots and kills his father to avenge the wrongs of his mother. In Philadelphia, an 18-year-old youth shoots a 14-year-old girl before turning the gun on himself because she would not love him. They go on to talk about New York and DC with 20-year-olds and 19-year-olds and feuds in Texas for a 19-year-old shooting someone. It's all these emotionally charged statements. They say these stories are ripped from the headlines, the Reconstruction era headlines, that is, but they could have been taken from today's news. They go on to say, and in the more than 150 years since the Reconstruction began, guns have gotten only deadlier. Automatic assault rifles can shoot 60 rounds per minute with enough force to liquefy organs. These are all the same emotional means-ends arguments that we heard before the Bruin ruling that Bruin said you can't do that anymore. What this court is clearly trying to do is they're trying to shoehorn something they're not supposed to do into Bruin by changing the focus of the history that they need to look to in order to justify their decision. So all of this is clearly not the writing of a clear-headed, focused judge looking for proper application of the law. This really reads a lot more like shock literature or something written for an emotional appeal. Now, it is true that Bruin did allow for consideration of the Reconstruction era when the 14th Amendment was ratified. That is something that they said, yeah, you can take that into consideration. But to make that the focus of a Second Amendment issue is completely missing the point. The law is not primarily an issue on state versus federal protection. That's not what this law is about. This law is truly about the foundational right of young adults to be able to protect themselves. Shifting the focus like this, courts are really using this as a way to deflect so many arguments that they have no way to defend otherwise. And we've seen similar attempts in this ruling in our lawsuits. In all of our lawsuits, the courts have really tried to shift the focus of the history away from that founding era to the Reconstruction era and beyond in order to find historical analogs. Something that's really interesting is that in the Bruin ruling, although Judge Thomas made allowances for the 14th Amendment, he talked about the Second Amendment 183 times. The 14th Amendment is only mentioned 22 times. So clearly, even if you look to Bruin as your benchmark for how much Second Amendment ratification and 14th Amendment ratification should be weighed and balanced when talking about these issues, it weighs so heavily in favor of the Second Amendment. But we're really excited about this because knowing our enemy's tactics is a huge part of the battle. If we know that the left is going to continue to try and shift focus away from the Second Amendment to the 14th Amendment, we can be prepared to strike down those arguments before they're even made. We need to make sure we are focused on keeping the arguments surrounding when the Second Amendment was ratified, full stop. And the good news is our lawyers are doing just that. So at this point, we're going to have to see what happens with this case as it goes further. As this one in Florida in the 11th Circuit ruled against 18 to 20-year-olds purchasing firearms, there was another ruling that happened in Texas on the federal level that actually the judge says, no, you can't have a law forbidding 18 to 20-year-olds from purchasing firearms. So there's a little bit of a split. The Texas one, they have decided not to appeal that to the 5th Circuit. However, this one, the NRA versus Bondi in the 11th Circuit, they have filed an appeal to have this case heard en banc. En banc just means instead of a 3-judge panel, they're going to open it up to more judges to rule on this. And we'll see if we get a different ruling. If we do end up with something with a big circuit split, we do hope that SCOTUS will get involved and that Judge Thomas will bring down a good ruling and help make clarity in situations like this, for cases like this, where people are trying to use not the Second Amendment, but the 14th Amendment in order to justify bad rulings. Well, thanks so much for your time. We look forward to seeing you again. Have a great day.